Good morning and welcome to an oral argument session of the 5th District Court of Appeals. I've already been introduced. To my right is Judge Richard Orfinger, and to my left is Judge James Edwards. We have 3 cases on the docket today. I would ask before we start that the parties and anybody in the gallery please silence any noise-making device, cell phone, etc., so it doesn't interrupt the lawyers in making their arguments. We had 2 cases on the docket previously, the Jorge Leal versus Cape Canaveral Hospital cases that have been resolved prior to this oral argument session. We have 3 cases on the docket now, 1 criminal and 2 civil. We'll be taking a break after the second case, which is the Matthews case, and would invite the lawyers. It needs to be limited to the lawyers back into the lawyers' lounge for coffee if they would like. And the criminal case will have 15 minutes per side, and the civil case is 20 minutes per side. Please advise if you want more or less than 5 minutes for your rebuttal if you're the appellant. I will assume 5 minutes unless you tell me differently. And the first case on the docket is Connelly versus the state of Florida, and the appellant may begin when ready.
May it please the court.
Yes.
Good morning.
Good morning.
My name is Bruce Limit. I was not the trial counsel in this case. I was not the original appellate counsel in this case. As the court is aware, there's an Anders brief that was filed by the original appellate counsel. This case returns this court to the somewhat murky and somewhat difficult area of jury instructions relating to justifiable use of deadly force. It seems that each case that comes along has a different nuance. This nuance relates to the failure of the trial court to provide an essential element of that defense, which really was a pathway for acquittal for Ms. Connelly, who was convicted and sentenced to a 20-year sentence.
And originally the instruction was the charge conference took place in the trial court, and there was the instruction that's in question was offered by the parties to the trial judge, and there was no objection, correct?
That's correct, and there is some indication in the transcript that the defense counsel at that time had some participation in the authoring of that jury instruction with the state. So apparently they both worked on it, at least what I'm gathering from the record. They both worked on it and was then presented to the court. Neither side objected to the giving of that instruction. So the issue is, initially, obviously, since there's no objection to it, is it fundamental error? And the state has raised the issue, has that been waived by the fact that it was requested, by the instruction was requested, there's no objection to it.
Counsel, let me ask you, the part of the instruction that was omitted is the second part. The first part was given that you can use force to prevent imminent death or great bodily harm. That was given.
Yes, sir.
And that part's okay.
Yes, sir.
The part that you're contending should have been given is, or to prevent the commission of either an aggravated assault or an aggravated battery. Is that right?
Correct. Generically, it's called a forcible felony. Those are the two that I described.
But those are the two.
Yes,
well,
sir.
let's kind of break that down. You know, to see, laying aside the question of whether it's fundamental error or not, even a fundamental error is subject to a harmless error analysis. So let's kind of break it down. The imminent commission of an aggravated assault. Let's look at an ag assault. It couldn't have been an ag assault because she didn't have a deadly weapon. I mean, she's threatening, there's no question she's threatening to, I'm going to kill you, I'm going to do this, but there's no deadly weapon. So how could that be an ag assault?
Judge, I respectfully disagree. You do not need a deadly weapon to commit an aggravated assault. You can commit aggravated assault if the intent is to do bodily harm to the individual.
So just words alone could constitute an ag assault? With
the ability to perform that aggravated assault. That is enough to satisfy that, and it's enough to charge somebody with that. Clearly, most of our cases of ag assault involve guns, firearms, but it's not required, and that's one of the issues that certainly would be...
Well, I thought an ag assault was a threat to do violence with the present ability to do so, and what made it an aggravated assault versus a regular assault was the presence of a deadly weapon.
That's one way it can be committed, but that's not the exclusive way an ag assault can be committed.
What would be the other way?
If the threat or the apparent ability was to do in fact serious bodily harm or death to the individual.
Okay, so let's talk about that. So, then we talk about an ag battery, and you agree that there's no deadly weapon involved on the part of the alleged victim.
Same response, there is no deadly weapon, but not an essential element of the ag battery.
But why isn't that all picked up by the first part of the instruction that says imminent death or great bodily harm? I mean, if she's threatening great bodily harm, if the jury had accepted that view, wouldn't that have encompassed the ag assault or the ag battery?
It would not, because the nature of the ag assault by definition is the threat to commit the crime. In other words, the words that are spoken with the apparent ability to commit that crime, that's what that crime is. And so someone is at that position of imminently, and understand that there can be a disconnect, but Florida legislature has included ag assault in one of the forcible felonies.
So is it you and I would agree that assuming that I really intended to do so, if I say I'm going to punch you in the nose, and I have the ability to jump over the bench, which at my age I don't, but I had the ability to do so, that would be a simple assault.
Well, first of all, I wouldn't be able to get away at my age from you.
Right, but that's a simple assault, right?
Not if you intended to do serious bodily injury.
So if I say, all I say is, I'm gonna punch you in the nose.
Without more?
Right, that more.
Assault.
So if I say, I'm gonna punch you in the nose and beat you to death, it's that second, and assuming I have the ability to do so.
Correct.
It's that second part, I'm going to beat you to death, that makes it an aggravated assault?
Correct. Because it elevates it to something much more serious than just the simple assault, if you have the apparent ability to do that. In this case, that's what we have. The alleged victim says that she is going to, without the expletives, kill Ms. Connelly. And that is the nature of a classic aggravated assault, not needing a weapon. I'm understanding, traditionally our ag assaults that we see have weapons, but in this case, it's not a required element. So under those circumstances, she was entitled to have that instruction read to the jury. And in fact, or that portion of the instruction read to the jury. And the jury would have to consider the case and evaluate the case as whether or not the state of Florida proved beyond a reasonable doubt that that had not taken place. That those elements of the reasonable, justifiable use of deadly force did not occur. And that instruction wasn't given. Now, the issue of, if I should move forward to the waiver issue, certainly there is case law relating to the fact if you ask for the instruction, you can't sort of play possum and then after a conviction come back and say, aha, you should have done that. The case relied upon the state goes back to a case which I think came from this court originally, State versus Armstrong, which went to the Supreme Court, which I think is a seminal case in this area. In Armstrong, there's a second-degree murder case where the defense asked for instruction concerning excusable homicide only to the issue of accident and not the other elements of excusable homicide. The defense attorney in that case argued that it was submitted for strategic reasons. He came in, according to the decision of the Supreme Court, to articulate and gave his reasons to the court, and the court eventually abided by the request. When it came back after conviction, the Supreme Court said, wait a second, you articulated it, you asked for it, you argued for it, you can't have it both ways. This case we would submit is different. This case, there's no evidence at all that it was a strategic reason for requesting this. In fact, there's no logical reason that you wouldn't ask for it. There's no separation between the two. And certainly, if in fact, and the benefit of this, I think, is consistent, Judge Offinger, with questions you're asking, that you don't need to have someone about ready to hit you. It's the words that you're going threatening to do that, which are part of the aggravated assault. And certainly, you can make an argument that doesn't make legal sense, but that's what's in the statute. And certainly, Ms. Connelly should have been able to avail herself of that jury instruction, so her defense could have utilized and the jury could have considered it. The second issue relating to the jury instructions related to the fact that the instruction concerning the justifiable use of non-deadly force was also given to the jury. That was erroneous to give that because as a matter of law, if there's a gun involved that's shot, it is by law deadly force. And certainly the jury, and there's no reason to give the non-deadly force instruction.
But how did that hurt? I mean, it just gave them another option if they wanted to find her not guilty.
Well,
I mean, I'm trying to understand. I agree it shouldn't have been given, but how did it hurt?
Problem is, there was no instruction given that the jury, if that is really at issue, the appropriate instruction is the jury needs to decide whether it's deadly force or non-deadly force and then go through with the instruction. They have to decide that first. When both are given and the non-deadly is given erroneously, the end of that instruction, Judge, says, if you find that it is not non-deadly force, you must convict the defendant. So the prejudice that arises is because of that instruction, this jury might not ever have considered deadly force and the instruction related to justifiable use of deadly force. Because they could have convicted her just based on finding it was not deadly force. And therefore giving it creates that problem that the conviction could have been based upon a jury never considering what her only legal defense was and considering based on the fact that a non-legal defense had been presented.
And then we have to do a fundamental error analysis because of the
Correct.
lack.
Absolutely. Absolutely.
Well, and isn't it highlighted, I mean, I note in quotes what was said in the charge conference where defense counsel said there's no objection, I mean, to justifiable use of deadly force or non-deadly force, and defense counsel said to the judge affirmatively, we're the ones wanting it in the fashion that it's presented to the trial court. So that gives to the trial court some indication that specific thought went into the way that instruction was agreed to presented to arguably the state, and then everybody agreed to that as what the trial judge was going to read. So why isn't that more consistent with the Armstrong case, that there was actual thought and it was strategic the way it was presented to the court?
Because I think there's a jump that the court has made between thought, which I think we're assuming, and I think rightfully so, and strategy. There's clearly no strategy to doing it this way. There is strategy to saying, okay, in a second-degree murder case, we only want excusable homicide to be accidental and not depraved mind or the other elements that you could utilize. In this circumstance, there's no logical strategy that can support that decision not to include that. There's no waste involved in it. There's no possible misleading of the jury. Right? It's just simply missed. And under those circumstances, this woman should not have a conviction survive with obviously the sentence that she received based on the fact that she has an instruction that doesn't include really her pathway that she should have had to be able to articulate for her acquittal.
And counsel, you're in your rebuttal time now, so if you want to save that or you want to continue.
I would like to save it. Thank you, Judge.
Okay.
Good morning, Your Honors, and may it please the Court, Marjorie Vincent Tripp on behalf of the state of Florida. Your Honors, whether or not the instruction that counsel proffers should have been given or should not have been given, the bottom line is the instruction as far as the use of deadly force that was given was requested by the defense counsel. And so there's really no fundamental error in this case. The court gave the exact instruction that was requested, and counsel can't establish otherwise that there was fundamental error. So it's the state's position that by assenting to this instruction that the defense waived any claim of fundamental error and the issue is not cognizable on direct appeal.
Do you think the instruction as it was given was erroneous? Laying aside the question of whether it's fundamental error or not, do you think it was error?
The use of deadly force instruction?
Yeah.
No, Your Honor, because what the defense argued below was that the use of force was required in order to prevent further assault or battery. There was no claim here under the forcible felony instruction that there was any aggravated assault or battery that was pending. So the instruction that was given based on the facts that was presented and based on the testimony that the defendant herself presented to the court that she was trying to prevent further harm and to dissuade the situation from going any further, then no, the forcible felony portion, I don't believe, not giving that was erroneous.
So you think that the, taking the evidence, which I understand we don't take it in their best light, but, it doesn't seem to be disputed that the alleged victim here is screaming something like, "I'm going to kill you," and that sort of thing. You don't think that that presents a forcible felony?
No, Your Honor. And in fact, what was argued in the initial brief was that there was an aggravated assault with the intent to commit an aggravated battery. And if you look at the language for aggravated battery, the statute specifically says a person commits aggravated battery who, in committing a regular battery, intentionally or knowingly causes great bodily harm or permanent disability or permanent disfigurement. So in this case, the defense would have had to show that the sister of the defendant intended to cause great bodily harm. I don't think there's any argument that can be made that what happened inside the house was a battery, but I don't know that they could prove to a jury that there was an intent to commit more than a battery once the incident went outside. So in that respect, I don't believe that the forcible felony instruction would have applied in this case, so it would not have been error for the court not to give it.
So charging down the steps and saying, "I'm going to kill you," it doesn't qualify in your view?
Well, there was dispute as to whether the sister actually was on the steps or whether, when Ms. Connelly was at the car or otherwise. The mother, in fact, was, I believe, the last witness to testify, and she, in fact, testified that the sister was standing on the front steps screaming at Ms. Connelly, and it was only when Ms. Connelly, who was in the car, the mother said, started to back up or move the vehicle, that was when the sister charged down the steps. So in that sense, one could argue that there really was no imminence as far as the allegation of an aggravated battery. As far as the non-deadly force instruction that was given, again, that was something that the defense assented to. If you look in the transcript, they specifically said that there was no objection because, quote, it mirrors section 3.6F. So again, any claim as to error with respect to the giving of that instruction was waived. With respect to the ineffective assistance of counsel, again, there's question as to why counsel didn't request the forcible felony portion of the instruction. We don't know, so we can't assume on direct appeal that it was ineffective assistance of counsel. Looking at the transcript, it's apparent that the defense counsel gave some thought to the way and the manner in which that instruction was presented. So if anything, we need an evidentiary hearing to determine what the strategy was, if any, and whether that it was a reasonable strategy by defense counsel. And finally, as far as the closing argument, our position is that there was no fundamental error. And in fact, we discussed with counsel and wanted to bring to the court's attention that in analyzing the first comment that the prosecutor made, which was referring to the reasonable person language as far as the aggravated assault statute is concerned, that actually was a correct statement of the law. The instruction specifically says that one of the prongs that the state has to prove is that the act of the defendant created in the mind of the victim a well-founded fear that the violence was about to take place. But it also goes on, and the court gave this portion of the instruction, that if the circumstances were such as to ordinarily induce a well-founded fear in the mind of a reasonable person, then the victim may have been found to have been in fear. So because the court gave a standard instruction, which again, there was no objection, and the standard instructions are presumed correct, it's our position that the prosecutor's statement was actually a correct statement of the law, and there was no fundamental error. The miscarriage of justice statement, again, that was proper. The prosecutor relied on the evidence to argue to the jury that it would be a miscarriage of justice based on the evidence that was presented to find that there was a justifiable use of deadly force in this case. So the bottom line, Your Honors, is we do not feel that there's any basis to reverse this case, and unless the court has any further questions, we would rely on our brief for the remainder of our arguments.
Thank you. And counsel, you've got about 3 minutes.
Thank you, sir. I would ask the court to look at the appellant's initial brief on page 16. We go through the elements of the aggravated assault, and that's patterned after Florida Jury Instruction 7.8. And the elements of that instruction the pattern instruction as we presented also is not the inclusion of a deadly weapon. And certainly I think under the circumstances, the fact that the woman is hollering after having beat the daylights out of my client inside the house, that she's going to kill her charging outside the house, is enough to establish the imminent commission of the aggravated assault. And that's what the instruction that should have been included would in fact define. And if the jury had followed that instruction or been provided that instruction, that would have had the ability to provide Ms. Connelly with an acquittal in this case and a reasonable theory. She did not have to have imminent physical danger to be killed to justify her shooting of the gun under the law. And as much as we think it might be a disconnect, the law is that way. That in fact is why, that is in fact the inclusion of forcible felony in that statute allows her to articulate that kind of a defense that should have been given. Respectfully, we disagree with the state. There just is simply no logical, strategic reason not to include that. It doesn't mislead. It doesn't set the jury off in an incorrect direction. And we would urge the court, if the court does find that fundamental error was waived, that in fact that the court can make a finding based on the Larry case, I think from this court, that in fact on its face, instead of wasting judicial resources on 3.85 motion to make a finding of ineffective assistance of counsel on the fact that this instruction was, the standard instruction was not given and the parts omitted were omitted with no logical reason. Thank you.
Thank you.